Mr. Milošević, it's now your opportunity to address us on the motions before us today. There's no need to repeat what's in the written submissions because we've read all those. It's also your opportunity to address us on the prosecution motion to amend the indictment. If there's anything you want to say about that, it's now your chance to do so.
In the first place, I'm not submitting any motions to this court because I do not recognize this court. If what I'm saying into this microphone is considered by you to be a submission on my part, that's up to you. Secondly, with respect to amicus curiae, it is my understanding that your explanation when appointing the amicus curiae was that thereby a contribution would be made to a fair trial. If in such an illegal proceedings one can talk of a fair trial, I think in doing so you have added a new concept to a set of new concepts, because now we are in a situation when two teams are working for the cause of the same party. So this could now be termed as the Hague fair play. As for this flood of new amendments and indictments, this deluge cannot flood and cover up the truth, because the truth is known to millions of people. I have heard here, as I heard on the previous occasion, some concern because I'm not reading the documents from this false indictment, because allegedly I should know what I'm charged with. Let me tell you, I know very well what I'm being accused of. I have been accused because in a legal way and with legitimate means, on the basis of the right to self-determination that belongs to every nation, I defended my nation. I had the honor to defend my nation from the criminal aggression carried out against it, and to defend my people from terrorism, whereby the Clinton administration cooperated closely with, and this is also something that no one will be able to deny. The truth cannot be sunk by any kind of flood of false accusations, and I have no intention still to familiarize myself with the contents of something that has been totally fabricated and that is far from the truth. As for the polemics I have been listening to as to who was competent and who was not, and whether a particular government should have done something prior to another government, I wonder and am astonished that not even the attorney from Belgrade, a member of the amicus curiae, that he should be speaking about competences while forgetting that no government had the competence to enter into arrangements whereby the Constitution of Serbia and the Constitution of Yugoslavia was being violated. I'm glad that the gentlemen from the amicus curiae are aware that they cannot speak on my behalf and that I have nothing in common with them.
Thank you. We will consider the preliminary motions on which we've been addressed this morning. We've had the opportunity of considering the application to amend the indictment, and I'll give our ruling on that. Rule 50 does not spell out any test to be applied in deciding whether leave to amend an indictment should be given. However, the cases in the tribunal show that the fundamental question is whether the amendment would cause injustice or prejudice to the accused if it were granted. In determining whether prejudice or injustice does arise, the issues a trial chamber must have in mind include the right of the accused to a fair and expeditious trial, including adequate time for preparation. On the other hand, the prosecution are entitled to amend an indictment, provided that the amendment is necessary and can be done without prejudicing the accused's right to a fair and expeditious trial. A trial chamber must balance these factors in coming to a decision. In the present case, the amendments substantially amount to the addition of one count, the particularizing of another count, the particularizing of a theory of responsibility, together with a modest increase in the factual allegations, to add a number of deportation sites to those already in the indictment, and to add some other factual matters. We have in mind that this is the second amendment to an indictment which is already 2 years old. But any trial on this indictment is more than 3 months away at least, and the accused therefore has adequate time for preparation. These amendments amount to a relatively insubstantial change in the indictment and occasion no prejudice or unfairness to the accused. In fact, they amount to an improvement by clarifying the prosecution case, in particular on joint enterprise and persecution. Accordingly, leave to amend the indictment will be granted. We now turn to the next stage, which is the reading of the Kosovo indictment. The second amended indictment will now be read, as Rule 62 provides, in a language which the accused speaks and understands. Let the indictment be read.
Tužilac Međunarodnog suda.
The prosecutor of the International Tribunal against Slobodan Milosevic and others, second amended indictment. The prosecutor of the International Criminal Tribunal for the former Yugoslavia, pursuant to her authority under Article 18 of the Statute of the International Criminal Tribunal for the former Yugoslavia, charges Slobodan Milosevic and others with crimes against humanity and violations of the laws or customs of war as set forth below. Accused. Slobodan Milošević was born on the 20th of August, 1941, in the town of Požarevac in present-day Republic of Serbia. In 1964, he received a law degree from the University of Belgrade and began a career in management and banking. Slobodan Milošević held the posts of Deputy Director and later General Director at Tehnogas, a major gas company, until 1978. Thereafter, he became President of Beogradska Banka, one of the largest banks in the former Socialist Federal Republic of Yugoslavia, the SFRY, and held that post until 1983. In 1983, Slobodan Milošević began his political career. He became chairman of the City Committee of the League of Communists of Belgrade in 1984. In 1986, he was elected chairman of the Presidium of the Central Committee of the League of Communists of Serbia and was re-elected in 1988. On the 16th of July, 1990, the League of Communists of Serbia and the Socialist Alliance of the Working People of Serbia were united. The new party was named the Socialist Party of Serbia, or the SPS, and Slobodan Milošević was elected its president. He continued to hold the post of the president of the SPS as of the date of this indictment. Slobodan Milošević was elected president of the presidency of Serbia on the 8th of May, 1989, and re-elected on the 5th of December that same year. After the adoption of the new Constitution of Serbia on the 28th of September 1990, Slobodan Milošević was elected to the newly established office of President of Serbia in multi-party elections held on the 9th and 26th of December 1990. He was re-elected on the 20th of December 1992. After serving 2 terms as President of Serbia, Slobodan Milošević was elected President of the Federal Republic of Yugoslavia, or the FRY, on the 15th of July 1997, and he began his official duties on the 23rd of July 1997. Following defeat in the September 2000 FRY presidential elections, Slobodan Milošević stepped down from this position on the 6th of October 2000. At all times relevant to this indictment, Slobodan Milošević held the post of President of the FRY. Paragraphs 5 to 15 deal with other individuals. Therefore, we continue with the reading of the indictment as of paragraph 16. Individual criminal responsibility. Article 7.1 of the Statute of the Tribunal. Each of the accused is individually responsible for the crimes alleged against him in this indictment under Articles 3, 5, and 7.1 of the Statute of the Tribunal. The accused planned, instigated, ordered, committed, or otherwise aided and abetted in the planning, preparation, or execution of these crimes. By using the word committed in this indictment, the prosecutor does not intend to suggest that any of the accused physically perpetrated any of the crimes charged personally. Committing in this indictment refers to participation in a joint criminal enterprise as a co-perpetrator. The purpose of this joint criminal enterprise was, inter alia, the expulsion of a substantial portion of the Kosovo Albanian population from the territory of the province of Kosovo in an effort to ensure continued Serbian control over the province. To fulfill this criminal purpose, each of the accused, acting individually or in concert with each other and with others, known and unknown, significantly contributed to the joint criminal enterprise, using the de jure and de facto powers available to him. This joint criminal enterprise came into existence no later than October 1998 and continued throughout the time period when the crimes alleged in counts 1 to 5 of this indictment occurred, beginning on or about the 1st of January 1999 and continuing until the 20th of June 1999. A number of individuals participated in this joint criminal enterprise during the entire duration of its existence, or alternatively at different times during the duration of its existence, including the accused Slobodan Milošević and others known and unknown. The crimes enumerated in counts 1 to 5 of this indictment were within the object of the joint criminal enterprise. Alternatively, the crimes enumerated in counts 3 to 5 were natural and foreseeable consequences of the joint criminal enterprise, and the accused were aware that such crimes were the likely outcome of the joint criminal enterprise. Despite their awareness of the foreseeable consequences, Slobodan Milošević and others known and unknown knowingly and willfully participated in the joint criminal enterprise. Each of the accused and other participants in the joint criminal enterprise shared the intent and state of mind required for the commission of each of the crimes charged in counts 1 to 5. On this basis, under Article 7.1 of the statute, each of the accused and other participants in the joint criminal enterprise bear individual criminal responsibility for the crimes alleged in counts 1 to 5. Article 7.3 of the statute of the tribunal. Slobodan Milošević and other accused, while holding positions of superior authority, are also individually criminally responsible for the acts or omissions of their subordinates, pursuant to Article 7.3 of the Statute of the Tribunal. A superior is responsible for the criminal acts of his subordinates if he knew or had reason to know that his subordinates were about to commit such acts or had done so, and the superior failed to take the necessary and reasonable measures to prevent such acts or to punish the perpetrators. Slobodan Milošević was elected president of the FRY on the 15th of July 1997 and assumed office on the 23rd of July 1997. At all times relevant to this indictment, he held the post of president of the FRY. As president of the FRY, Slobodan Milošević was president of the Supreme Defense Council of the FRY. The Supreme Defense Council consists of the president of the FRY and the presidents of the member republics, Serbia and Montenegro. The Supreme Defense Council decides on the National Defense Plan and issues decisions concerning the VJ or Yugoslav Army. As president of the FRY, Slobodan Milošević had the power to order implementation of the National Defense Plan and command the VJ in war and peace pursuant to decisions made by the Supreme Defense Council. Slobodan Milošević, as Supreme Commander of the VJ, performed these duties through commands, orders, and decisions. Under the FRY law on defense, as Supreme Commander of the VJ, Slobodan Milošević also exercised command authority over Republican police units subordinated to the VJ during a state of imminent threat of war or a state of war. A declaration of imminent threat of war was proclaimed on the 23rd of March 1999 and a state of war on the 24th of March 1999. In addition to his de jure powers, at all times relevant to this indictment, Slobodan Milošević exercised extensive de facto control over numerous institutions essential to or involved in the conduct of the offences alleged herein. Slobodan Milošević exercised extensive de facto control over federal institutions nominally under the competence of the Assembly or the government of the FRY. Slobodan Milošević also exercised de facto control over functions and institutions nominally under the competence of Serbia and its autonomous provinces, including the Serbian police force. Slobodan Milošević further exercised de facto control over numerous aspects of the FRY's political and economic life, particularly the media. Between 1986 and the early 1990s, Slobodan Milošević progressively acquired de facto control over these federal, republican, provincial, and other institutions. Slobodan Milošević's de facto control over Serbian SFRY, FRY, and other state organs stemmed in part from his leadership of the two principal political parties that ruled in Serbia from 1986 to 2000, and in the FRY from 1992 to the year 2000. From 1986 until 1990, he was chairman of the Presidium of the Central Committee of the League of Communists in Serbia, then the ruling party in Serbia. In 1990, he was elected president of the Socialist Party of Serbia, the successor party to the League of Communists of Serbia and the Socialist Alliance of the Working People of Serbia. Throughout the period of his presidency of Serbia, from 1990 to 1997, and as the president of the FRY from 1997 to the year 2000, Slobodan Milošević was also the leader of the SPS. Beginning no later than October 1988, and at all times relevant to this indictment, Slobodan Milošević exercised de facto control over the ruling and governing institutions of Serbia, including the MUP. Beginning no later than October 1988, he exercised de facto control over Serbia's two autonomous provinces, Kosovo and Vojvodina, and their representation in federal organs of the SFRY and the FRY. From no later than October 1988 until mid-1998, Slobodan Milošević also exercised de facto control over the ruling and governing institutions of the Republic of Montenegro, including its representation in all federal organs of the SFRY and the FRY. In significant international negotiations, meetings, and conferences since 1989, and at all times relevant to this indictment, Slobodan Milošević was the primary interlocutor with whom the international community negotiated. He negotiated international agreements that were subsequently implemented within Serbia, the SFRY, the FRY, and elsewhere on the territory of the SFRY. Among the conferences and international negotiations at which Slobodan Milošević was the primary representative of the SFRY and FRY are the following: The Hague, primary representative of the FRY, the Hague Conference in 1991, the Paris negotiations of March 1993, the International Conference on the former Yugoslavia in January 1993, the Vance-Owen Peace Plan negotiations between January and May 1993, the Geneva Peace Talks in the summer of 1993, the Contact Group meeting in June 1994, the negotiations for a ceasefire in Bosnia-Herzegovina between the 9th and 14th of September 1995, the negotiations to end the bombing by the North Atlantic Treaty Organization, NATO, in Bosnia-Herzegovina from the 14th to the 20th of September 1995, and the Dayton peace negotiations in November 1995. As the President of the FRY, the Supreme Commander of the VJ, and the President of the Supreme Defense Council, and pursuant to his de facto authority, Slobodan Milošević is criminally responsible for the actions of his subordinates within the forces of the FRY in Serbia, which included the VJ, the Republic of Serbia Ministry of Interior, or MUP, military territorial units, civil defense units, and other armed groups operating under the authority or with the knowledge of the 8 accused and their subordinates who committed the crimes alleged in counts 1 to 5 of this indictment. Slobodan Milošević, as President of the FRY, Supreme Commander of the VJ, and President of the Supreme Defense Council, is also, or alternatively, criminally responsible for the acts of his subordinates, pursuant to Article 7.3 of the Tribunal Statute, including, but not limited to, members of the VJ and the aforementioned personnel of other forces of the FRY and Serbia for the crimes alleged in counts 1 to 5 of this indictment. In addition, Slobodan Milošević, pursuant to his de facto authority, is also alternatively criminally responsible for the acts of his subordinates, pursuant to Article 7.3 of the Tribunal Statute, including members of the VJ and employees of the MUP for the crimes alleged in counts 1 to 5 of this indictment. Paragraphs 29 to 52 relate to other accused, and therefore we continue with the reading of this indictment with paragraph 53.
Charges. Following the commencement of the joint criminal enterprise beginning on or about the 1st of January 1999 and continuing until 20th of June 1999, Slobodan Milošević and others known and unknown planned, instigated, ordered, committed, or otherwise aided and abetted a deliberate and widespread or systematic campaign of terror and violence directed at Kosovo Albanian civilians living in Kosovo in the FRY. The deliberate and widespread or systematic campaign of terror and violence directed at the Kosovo Albanian population was executed by the forces of the FRY and Serbia, acting at the direction, with the encouragement, or with the support of Slobodan Milošević and others known and unknown. Forces of the FRY and Serbia undertook the operations targeting the Kosovo Albanians with the objective of expelling a substantial portion of the Kosovo Albanian population from Kosovo in an effort to ensure continued Serbian control over the province. To achieve this objective, the forces of the FRY and Serbia, acting in concert, engaged in well-planned and coordinated operations as described in paragraphs 55 to 61. The forces of the FRY and Serbia, in a deliberate and widespread or systematic manner, forcibly expelled hundreds of thousands of Kosovo Albanians from their homes and internally displaced them within Kosovo. To facilitate these expulsions and displacements, forces of the FRY and Serbia intentionally created an atmosphere of fear and repression through the use of force, threats of force, and acts of violence. Throughout Kosovo, the forces of FRY and Serbia engaged in a deliberate and widespread or systematic campaign of destruction of property owned by Kosovo Albanian civilians. This was accomplished by the widespread shelling of towns and villages, the burning and destruction of property, including homes, farms, businesses, cultural monuments, and religious sites, and the destruction of personal property. As a result of these orchestrated actions, villages, towns, and entire regions were made uninhabitable for Kosovo Albanians. In addition to the deliberate destruction of property owned by Kosovo Albanian civilians, forces of the FRY and Serbia committed widespread or systematic acts of brutality and violence against Kosovo Albanian civilians in order to perpetuate the climate of fear, create chaos, and a pervading fear for life. Forces of the FRY and Serbia went from village to village and in the towns and cities from area to area, threatening and expelling the Kosovo Albanian population. Kosovo Albanians were frequently intimidated, assaulted, or killed in public view to enforce the departure of their families and neighbors. Many Kosovo Albanians who were not directly forcibly expelled from their communities fled as a result of the climate of terror created by the widespread or systematic beatings, harassment, sexual assaults, unlawful arrests, killings, shelling, and looting carried out across the province. Forces of the FRY and Serbia persistently subjected Kosovo Albanians to insults, racial slurs, degrading acts, and other forms of physical and psychological mistreatment based on their racial, religious, and political identification. All sectors of Kosovo Albanian society were displaced, including women, children, the elderly, and the infirm. Thousands of Kosovo Albanians who fled their homes as a result of the conduct of the forces of the FRY and Serbia and the deliberate climate of terror that pervaded the territory of Kosovo joined convoys of persons that moved towards Kosovo's borders with the Republic of Albania and the former Yugoslav Republic of Macedonia. Along the routes to the border crossings, forces of the FRY and Serbia manned checkpoints where the displaced Kosovo Albanians were subjected to further beatings, extortion, robbery, harassment, assaults, illegal arrests, and killings. At other times, forces of the FRY and Serbia escorted groups of expelled Kosovo Albanians to the borders. By these methods, the forces of the FRY and Serbia maintained control over the movement of displaced Kosovo Albanians to the borders. Displaced Kosovo Albanians often arrived at the borders of Kosovo on foot in convoys of several thousand persons or carried by tractors, trailers, and trucks, as well as on trains, buses, or trucks, which were organized and provided by forces of the FRY and Serbia. In addition, thousands of Kosovo Albanians who fled their homes and were thereby forcibly transferred as a result of the conduct of the forces of the FRY and Serbia and the deliberate climate of terror that pervaded the territory of Kosovo, were forced to seek shelter for days, weeks, or months in other towns and villages, and/or in forests and mountains throughout the province. Some of these internally displaced persons remained inside the province of Kosovo throughout the time period relevant to this indictment, and many persons died as a consequence of the harsh weather conditions, insufficient food, inadequate medical attention, and exhaustion. Others eventually crossed over one of the Kosovo borders into Albania, Macedonia, Montenegro, or crossed the provincial boundary between Kosovo and Serbia. Forces of the FRY and Serbia controlled and coordinated the movements of many internally displaced Kosovo Albanians until they were finally expelled from Kosovo. Throughout Kosovo, in a deliberate and widespread or systematic effort to deter expelled Kosovo Albanians from returning to their homes, forces of the FRY and Serbia looted and pillaged the personal and commercial property belonging to Kosovo Albanians. Forces of the FRY and Serbia used wholesale searches, threats of force, and acts of violence to rob Kosovo Albanians of money and valuables, and in a widespread or systematic manner, authorities at FRY border posts stole personal vehicles and other property from Kosovo Albanians being deported from the province. In addition, throughout Kosovo, forces of the FRY and Serbia systematically seized and destroyed the personal identity documents and licenses of vehicles belonging to Kosovo Albanian civilians. As Kosovo Albanians were forced from their homes and directed towards Kosovo's borders, they were subjected to demands to surrender identity documents at selected points en route to border crossings and at border crossings with Albania and Macedonia. These actions were undertaken in order to erase any record of the deported Kosovo Albanians' presence in Kosovo and to deny them the right to return to their homes. Count 1. Deportation. The prosecutor realleges and incorporates by reference paragraphs 55 to 61. Beginning on or about 1st of January 1991 and continuing until the 20th of June 1999, forces of the FRY in Serbia, acting at the direction, with the encouragement or with the support of Slobodan Milošević and others known and unknown, perpetrated the actions set forth in paragraphs 55 through 61, which resulted in the forced deportation of approximately 800,000 Kosovo Albanian civilians. To facilitate these expulsions and displacements, forces of the FRY in Serbia deliberately created an atmosphere of fear and oppression through the use of force, threats of force, and acts of violence, as described above in paragraphs 55 to 61. Throughout Kosovo, forces of the FRY in Serbia systematically shelled towns and villages, burned homes and farms, damaged and destroyed Kosovo Albanian cultural and religious institutions, murdered Kosovo Albanian civilians, and sexually assaulted Kosovo Albanian women. These actions were undertaken in all areas of Kosovo, and these deliberate means and methods were used throughout the province, including the following municipalities: Orahovac. On the morning of the 25th of March 1999, forces of the FRY in Serbia surrounded the village of Celine with tanks and armored vehicles. After shelling the village, forces of the FRY in Serbia entered the village and systematically looted and pillaged everything of value from the houses, set houses and shops on fire, and destroyed the old mosque. Most of the Kosovo Albanian villagers had fled to a nearby forest before the army and police arrived. On the 28th of March 1999, forces of the FRY in Serbia forced the thousands of people hiding in the forest to come out. After marching the civilians to a nearby village, the men were separated from the women and were beaten, robbed, and all of their identity documents were taken from them. The men were then marched to Prizren and eventually forced to go to Albania. On the 25th of March 1999, a large group of Kosovo Albanians went to a mountain near the village of Nogavac, also in Orahovac municipality, seeking safety from attacks on nearby villages. Forces of the FRY in Serbia surrounded them and on the following day ordered the 8,000 people who had sought shelter on the mountain to leave. The Kosovo Albanians were forced to go to a nearby school, and then they were forcibly dispersed into nearby villages. After 3 or 4 days, forces of the FRY in Serbia entered the villages, went from house to house, and ordered people out. Eventually, they were forced back into houses and told not to leave. Those who could not fit inside the houses were forced to stay in cars and tractors parked nearby. On the 2nd of April 1999, forces of the FRY and Serbia started shelling the villages, killing a number of people who had been sleeping in tractors and cars. Those who survived headed for the Albanian border. As they passed through other Kosovo Albanian villages which had been destroyed, they were taunted by forces of the FRY and Serbia. When the villagers arrived at the border, all their identification papers were taken from them. In the course of the expulsions throughout the entire municipality of Orahovac, forces of the FRY and Serbia systematically burned houses, shops, cultural monuments, and religious sites belonging to Kosovo Albanians. Several mosques were destroyed, including the mosques of Bela Crkva, Brestovac, Velika Kruša, and others. Prizren. On 25th of March 1999, the village of Pirane was surrounded by forces of the FRY and Serbia with tanks and various military vehicles. The village was shelled and a number of the residents were killed. Thereafter, forces of the FRY and Serbia entered the village and burned the houses of Kosovo Albanians. After the attack, the remaining villagers left Pirane and went to surrounding villages. In the town of Landovica, an old mosque was burned and heavily damaged by forces of the FRY and Serbia. Some of the Kosovo Albanians fleeing towards Srbica were killed or wounded by snipers. Forces of the FRY and Serbia then launched an offensive in the area of Srbica and shelled the villages of Donji Retimlje, and Randubrava. Kosovo Albanian villages were forced from their homes and sent to the Albanian border. From the 28th of March 1999, in the city of Prizren itself, forces of the FRY and Serbia went from house to house ordering Kosovo Albanian residents to leave. They were forced to join convoys of vehicles and persons traveling on foot to the Albanian border. En route, members of the forces of the FRY and Serbia beat and killed Kosovo Albanian men, separated Kosovo Albanian women from the convoy, and sexually assaulted the women in view of others. At the border, all personal documents were taken away by forces of the FRY and Serbia. Srbica. Beginning on or about the 25th of March 1999, forces of the FRY and Serbia attacked and destroyed the villages of Vojnike, Leočina, Kladernica, Turicevac, and Izbica by shelling and burning. Many of the houses, shops, and mosques were destroyed, including the mosque in the center of the village of Čires. Some women and children were taken away by members of the forces of the FRY and Serbia and held in a barn in Čires. The women were subjected to sexual assault and their money and property was stolen. At least 8 of the women were killed after being sexually assaulted, and their bodies were thrown into 3 wells in the village of Čires. On or about the 28th of March 1999, a group of at least 4,500 Kosovo Albanians from these villages gathered in the village of Izbica, where members of the forces of the FRY and Serbia demanded money from these Kosovo Albanians and separated the men from the women and children. A large number of the men were then killed. The surviving women and children were forcibly moved as a group towards Klina and Đakovica, and eventually to the Albanian border. Suva Reka. On the morning of the 25th of March 1999, forces of the FRY and Serbia surrounded the town of Suva Reka. During the following days, police officers went from house to house, threatening, assaulting, and killing Kosovo Albanian residents and removing many of the people from their homes at gunpoint.